to the next session. We have Joseph. We have known each other for like quite some time now. Joseph is an alumnus of National Law School, Bangalore. He has been in legal profession for almost more than a decade, I'm assuming. More than 2 decades, actually, right? But like having spent this much amount of time, he is equally passionate about legal technology. I think his love for legal ontologies is something that we continue to discuss a lot. And I think we are looking forward to your presentation and what you have been up to, Joseph. So over to you.
Yeah, good afternoon, everybody. Justice Chapter and the great faculty here. So my topic today is legal matters specification standards. And I think it's important, therefore, to understand you all understand ontologies. You can hear me, right? Yeah. You all understand ontologies, and let me explain the background of this entire talk. Recently, there was an organization which is called a conglomeration of organizations called the Judicial Data Collaboration. Asked me to whether, knowing my interest in ontologies and legal standards and legal matter specifications, asked me whether I would willing to chair this entire subject for them. It's a group of organizations, Agami, Daksh, where we have all been part of discussions on many of these areas. And what came out crucially in some of our internal discussions was there was lack of standardizations in the law. I mean, there's lack of standardization not only in the Indian law, there's lack of standardizations in the international laws as well. The language which the US lawyers speak, though the concepts may be same, is totally different in India. It's you have concepts like demurrer in the US, which may not have an equivalent title in India. And that creates issues not only for our students who are trying to understand the law and understand that while the concepts may be same, sometimes they don't understand that it means the same thing. And so when you are reading about it, you would be able to see the context better. Now, this problem appears all the more so in the enterprise space, where to a large part of where I work. That's when you look at enterprises, you have organizations on one hand, you have law firms on the other hand, you have the various vendors, because if you see the legal tech industry today now has several verticals, and there are several of these tech industries working in various silos. You have people for practice management, you have people for contract lifecycle management, you have people for clustering, you have people working across various aspects. Now, how do these organizations, and they're all dealing with the same amount of data. Now, how do these organizations speak to each other if you have different ways of how do you classify your information? Now, if you talk in terms of our judgments, for example, now the Agami folks would talk about it as rhetorical roles within judgments. When you classify judgments, you classify it as rhetorical roles. Somebody else calls it as data labeling. Somebody calls it annotation. Now, what is the actual name and what's the actual terminology for this? Now, you have the same issues. I mean, it can go on in terms of you have defamation, and especially I'm seeing this, you put a prompt in ChatGPT on a subject which you would generally think it would come out with the defamation. The obvious subject would be defamation. But the answers to which you get could be slightly more nuanced. It could be because it is essentially on languages, and it's a semantic search, and you could get the entire responses which you get could sometimes border from a legal perspective on aspects relating to criminal misstatement. It could be negligent misstatement, and some could be libelous. Now, how would technology understand that an act which would be defamatory in some sense could sometimes also be labeled by technology as a libelous act, in terms of, and they all in law, the differences is in some case it's so nuanced. While they could be criminal and civil, they have got criminal there are criminal liabilities arising, or in some cases, some civil liabilities do arise. Now, you look at take for example, if you are studying a case on murder in an Indian context, and if you want to see a parallel in the US, the concept of murder may not exactly be there. It may be called manslaughter. Now, across, it's all the most, these issues would arise from a contractual lawyers we normally face. Some people call it force majeure, somebody calls it act of gods. There are various of these terminologies. And sometimes when you look at these clauses, in every agreement in an enterprise, you would have the same clause as a boilerplate clause. It could be in the human resources department. It could be in a typical commercial transaction, which could be a buy and sell transaction. It would be the same clause, but it's got its own connotations. Take, for example, any of the obligations which may be present in a standard contract would vary depending on whether it's a buy or sell side. Okay. Now, if it's a buy side, obviously the clauses would vary. If it's a sell side, the clauses would change. Take, for example, the payment clauses. Now, how do you classify that this is a payment consideration clause specifically meant for a buy side? And especially if you're looking at a situation, if I ask ChatGPT to draft an agreement for me, for an average lawyer, he would not understand that this is a buy side clause or a sell side clause. Okay, he would only pick it up saying that, okay, the machine has drafted it for me, I will go ahead with it. Now, that is the context in which we felt that it may be it may be necessary for us to essentially get into classification of all of these contract types. Because otherwise, when you do a standard semantic search, you would never get the appropriate results. Okay, and even a large language model like GPT-3 or the next couple of languages is the problem is only going to get worse because you're training on a larger set of data, and none of these data are essentially classified in such a manner or standardized in such a manner whereby the information could be accurate and to avoid what we call the hallucination factor. GPT-3, everybody understands, is so brilliant in terms of its output that it can mistake most average people because of the clarity in which it probably analyzes and summarizes stuff. So that is the context in which why we all the more feel that when it comes to searches on legal, it is important that we specify and we standardize the entire language and the entire language which surrounds this. Okay, the entire legal fields. So let me just go on. Now, there are different types of standards. One could be the metadata standards. Now, many of you all are aware of use a Microsoft Word document. The standards in it, the metadata standards are based on the Dublin Core. It could be based on LMSS, all of those. There's something called mods. That's the I think that's the American Library State, the Union Library, those standards. And there are various library. And so when you look at your metadata in your Microsoft Word document, it quickly picks up these metadata standards. Then there could be these content standards. Content standards are those standards which are specified as to what, if it is this content, this is what the standard which would be indicate like one NDA is a company which prescribes the format of non-disclosure agreements, which should be adopted across, which should be what we call the least negotiable, or what they call as a standard or their boilerplate, which is suggested to everybody within their member groups, so that you do not debate, or negotiate unnecessarily on clauses which could be otherwise agreed on by the industry. Now, they are what we call content standards. Then there are content standards also in the what we call the construction industry, which we call the FIDIC content standards. They are very specific to that. So everybody adopts a particular standard. Then comes the process standards. The process standards are those standards which may apply to specifically to the legal community, which could be like your project, your case management software, how your courts could essentially manage. There could be a process around how it works. And then you have this contract lifecycle management, which also works on certain things called the process standards. Now let's deal with the metadata standard, and that's where that's the focus of my talk today. That when we deal with metadata standards, and we do talk in terms of lawyers look at it, you first look at it from the perspective of what the matter is, and that's what we call the matter metadata. Then we look at it from the perspective of the document, and what's the document type, what's the purpose and intent of the document, so that we would be able to categorize. If it's a merger agreement or you're acquiring a company, you would categorize everything around it to being that nature of a merger agreement. Then comes, of course, the timekeeping part. So when I talk of all of these standards that people, lawyers, and I think many parts of the world, when you work on a matter, you essentially need to keep time. And how do you keep time more robustly? I mean, traditional way of keeping time was at the end of the day, you note down on a paper. But nowadays, technology has so evolved that when you work on matters, the time is kept in the background. And there's a separate standard for that. And similar across the industry, there has been now metadata standards which are being evolved, which could help in the entire process of standardization. So when we talk in terms of legal matter specification standardization, we try to solve many of these issues, which could be due to inconsistent format, lack of a consolidated data, the lack of interoperability. What does interoperability mean? So when an organization is, for a company which is working in all parts of the world, it gives works to its law firm. Okay, the law firm relies on third-party vendors, and if information has to play around between these three entities, between the client, for example, if assuming the Microsoft is a client, gives its work to a local lawyer. If they don't speak the same language, then the APIs don't transfer, because one organization will not be able to understand what the other organization is talking. Though they might be speaking everything else, everybody knows what is being delivered. But if your terminology is not right, then the APIs do not work. That is where we believe that it is all the more important, and it's part of an entire thing, that you need to follow an ontology. And if you do not follow ontologies, you would end up working in silos. You would structure information well. And what Saurabh mentioned in the last session about why you need to work in open source, why you need to work with everybody together, because if we do not speak the same language, we'll all be working in silos and cross purposes. And that's the context in which why this entire effort is being made in terms of, can we arrive at a standard for legal? Okay, and that's the context in which I would be presenting my seminar. More from a perspective, it's not purely about integrations, it's also about making your information machine ready so that the computers could grasp it and understand it. And we all speak that the understanding between all of us is the same. Now, if we, and it is not rocket science, a standard at various levels, you could have an XML with an RDF and an OWL, depending on the levels at which you want to go to. You could do a basic taxonomy level, or you can get into a slightly more detailed ontology level with the OWL, which is the ontology web language, at the second layer. Now, these could have various applications, more specifically, and I feel this with large language models coming in. The knowledge representation and what we did, what Saurabh and was discussed in the last session is, how do we essentially make sure that when we use those large language models like GPT on a specific database and try to get the closest match possible, how do we essentially work within a construct so that it is not searching the entire wild web, but working within the database which it works, and gets the most accurate information? And why am I saying this? Because in law, one of the most important criteria is there has to be explainability. If there is no explainability, in the sense that citizens should get a right, and if I'm taking it to the extreme, if we are looking at predictive analytics, and we take predictive analytics to a situation there, it's going to be the judgments could be augmented with the help of information technology. If we have to reach that stage, we cannot work in a black box. The minute you have a black box, then you're not giving confidence to the citizen, because the citizen does not understand what is the explanation for such a reason. So that is where you really then need to think in terms of it. Is that black box? Is there how does it all arise? Is the citizen getting a right to an explanation for a decision which was taken? Has the current problems of hallucination been avoided? Could there have been a vertically trained thing that you have all the great summarization facilities, and you have all of the great semantics and the abilities to structure good arguments from GPT, and use it within a specific database and get the effective results. That is all possible in our view from using matter standardization and matter specific standardization. What also it does is you could have a situation where you could dictate, you could give instructions to the computer to take out a plaint or create a repetition. And it would be able to, and in what context, you would be able to see what we could, they call it, I think Microsoft has Copilot. Everybody uses Copilot nowadays. It's part of your GitHub and in terms of, and what it is, it just provides an assistant for you for coding. For lawyers in future, if you want to draft an agreement and you can say, draft a sell-side agreement between a chemical company and another company, the system should be able to take it out. And that can only be possible if you are able to have all of these ontologies fixed in with the specific details which industry requires. And that is where, the entire context in which we see it is this, that the whole world to some extent, and at least the largest of the vendors, are now moving to what is called a common language. And they have adopted a language which we call as SALI. SALI stands for Standards Advancement for the Legal Industry. Okay, so whether you look at the law firms, you look at many of the service providers, like the DMS providers, that's the document management service providers. And you have the various vendors in the industry in terms of the search providers, have all adopted SALI, which is a standard for ontology. It's now, SALI is right now has content of 5 countries. It's the US, Canada, Germany, and I think some cases Australia as well, and UK as well. So what it does is this, of course, one is the interflow of information. Then is the aspect of enhanced legal information retrieval, better automation, and improved accountability. Now let's see how it works. For example, this is a typical standard ontology framework, which I can just run you through. And you could see how the ontologies work. So for example, it's logged in, it's on a Stanford University website. You could see each of the breakdowns of the various laws and how the taggings work with those very specific ontologies. It works with these specific we are right now dealing with over 10,000 odd tags. And it shows each of those tags, the location, what it means, what its context is, and what its relationships are across an ontological framework. And it includes the various sort of parents of each of these phrases and what could be the alternate labels. And you could also have the alternate labels across jurisdictions and countries. And you could essentially keep an entity graph and show relationships between one sector and the other, and understand what possibility is there that there could have been misrepresentations. And this in Crux, it could be downloaded. It is open source. Anybody could use it. So now these sort of ontologies could be spread across databases. It could be spread across sectors. It could be spread across industries. It could be spread out at various levels. The semantic levels could also be significant, and it enables what we call the abilities to essentially get information categorized under specific heads. Take, for example, similar ontologies could work for a contract. And when the same ontologies are picked and put in an ODR setting, then you would be able to understand how, right from the stage when the contract is drafted and to stages where disputes do get arisen, they could all be mapped in from a perspective of an ontology framework. And how does it help? Because also you could understand where are the possibilities of these issues arising. And at that stage, you could probably decide these are the areas where you need to probably tie in an ODR or an arbitration facility, because because you understand where the friction points are. You understand where possibility issues are going to arise. Same with respect to legal ontologies for litigation. You would be able to do docket management, clustering, all of which far more easily if it is all structured with an ontological basis. Now coming to what we are doing, and in fact, I did discuss that we are trying to create an ontology within the Indian framework. Of course, there's no point reinventing the wheel. So we have in discussions with these standards advancement in the legal industry, trying to work with to create Indian framework. And that's the context in which we have reached out to several organizations, Daksh and Agami included, to join in this effort to create a working group to work on similar ontologies in India. So this essentially means, so right now a decision has been taken that we will take two working groups. That is one for banking law and one for insurance. Those are the areas where it's all mapped out because there is a significant ODR presence also in banking and insurance. And we are looking at getting the best of practitioners in helping us in developing these ontologies or collating these ontologies with what may be available elsewhere in the West. These are processes which are both asynchronous and synchronous. Asynchronous meaning that you could work on your own time, send it to us. And sometimes we could meet in synchronous meetings and decide this together. And we could finalize an ontology between India. Nothing is cast in stone. These ontologies, if it is indicated that it is not appropriate, it's not correct, we could always change it. And that's the benefits of ontology. We would map local legal terms to an international setting. That is, what may be have been part of an international ontological framework. We would map it to it. The aim is this, that tomorrow, such mappings could also help in very complex arbitrations where there are complexities of the laws and laws which would be so that you could understand how local laws flavor with regard to the international laws. We look at various modes by which this ontologic framework could be created. And of course, now when we do talk in the terms of this, we could use large language models also to do this. So, so this is, for example, what you see on the screen is by a professor called Dan, who has created this with regard to the US tax code and who has mapped out what are the possible linkages between the US tax code and every other area of law or industry. Okay, so he has mapped it out using GPT. Now, similar sort of structures we could also undertake here in India. Now, the interest is this, that if there are any questions, I'm more than happy to take them. And more specifically, this is a call out to all professionals and academics working in the banking and insurance sectors to join us in contributing and being part of these working groups. So we could create an ontology specific to these sectors. Yeah, thank you. If there are any questions, I'm more than willing to take it. Yeah, good. Yeah, one second.
So good morning, sir. It's a really interesting topic, standardization of legal documents. And my question is regards to standardization of the petitions, the administrative documents, the summons, the notices that are issued from the court's end. And I see, since I'm working in this field, I see that all the district courts in various states and all the high courts have a very different understanding of the templates that they use. And thereby there is no standardization per se. And due to this lack of standardization, I believe AI is also having a difficulty to classify those documents and then to automate the processes at the end of the day. Because if the processes are not automated, it's going to take a lot of time. And it does takes a lot of time to issue summons, whether the summons are reaching the litigants or not in time. And therefore, there is a significant delay. So are you also looking at creating ontologies for legal processes in that regard? And is it necessary to do so?
Firstly, I think there is some standardization because for most court documents, there are some standardization, because if take for example the Supreme Court, if you file an SLP, you need to file it in Form 28. That's the format of an SLP, and in those also there are only 3-4 variable fields. You only can insert the list of dates, the grounds, and and probably the questions of law. Okay, there's some standardized. If I have to run a machine learning model on it, I know I will only have to go into these 3 sections and read it, because everything else should be gone. Lawyers, of course, experiment on it. Okay, as far as most courts generally have some standard forms by which you could essentially, has some basic standardization. So it is possible that in some courts there is an extra linguistic little flourish which is added by lawyers, which sometimes does not help in that standardization process. But otherwise, most of these new tribunals also have specified the format in which the pleadings have to be made. Okay. Yeah. So when we do look at standardization in this, as the slide would probably would reveal, it's got multiple objects, including the most obvious one being how do you make it more? How do you make the legal documents? We call it the legal exhaust, because every legal document has got an exhaust. Okay, there's certain information, there's metadata, which all could be captured, and they are all information for the future. If stored appropriately, it could be used in multiple levels. It could be used from a perspective of it being a precedent. It could be used from a perspective of it being used by subsequent good as a finished work product. I'm talking of in terms of contracts, and subsequently it becomes also what we would call the basis of all litigations. Because take for example a contract. If a contract is not managed properly, and if it not follows what you call the playbooks of the company, yes. It is beyond the checklist. It is beyond checklist, because actually, correct. Okay. So you mentioned medical domain. Let me answer that. And probably this entire concept of checklist came from the checklist manifesto from Dr. Atul Gawande. So, that's the most classic. And they found that after that was followed, the levels of hospitalizations come down, and rather post-admitting, the number of issues came less in terms of the post-operation issues were sorted out, right? Similarly, it's the same process, and that's the reason why organization keeps what we call playbooks. So every time an issue gets into dispute, then there is a sanitization drive which goes across organizations. And if you look at the maximum amount of funding which has gone in the legal tech sector, has been specifically for this in the contract lifecycle management. It is to manage the entire, and those contract lifecycle management would not have worked if we did not have this checklist. Okay, so that's the context. So while it may not be correct to say that it's got only these particular approaches, ontologies by the very definitions are malleable. You could build on top of it. You can build multiple layers on top of it. The entire concept of these co-pilots, as we talked about, it works on the same principle. Yeah. Yeah, go ahead.
Yeah, so I just wanted to understand in terms of standardization, are you speaking in terms of templatizing certain aspects of legal documents? So for instance, in open source softwares, you have so many different types of open source licenses, and to use those licenses, people simply put, okay, this is under this protected under common Creative Commons license and all. So is it in terms of that, or standardization in terms of creating some sort of a domain specific language through which you can generate representations of a particular legal document, and then compare it with existing frameworks?
It's all of the above. So when we do look at standardization, so content it works only if you marry it with context. Okay. And when you look at, when I talk in terms of context and content, essentially creates the best ontology. Then when you marry it with industry, when you marry it with state, when you marry it with jurisdiction, when you marry it with the players, actor players, and what are you in the ecosystem, that's when the entire object. So when you see some of these levels at which these ontologies go, probably go 7 to 8 levels deeper. Okay. So that's the extent is this. So it is like, it is obviously, it's in the traditional context, this is the basis on which the recommendation engines would work. Okay, so if you are searching specifically on this, your entire future recommendations will work only within that ontology or the vector space in which we are looking at. Okay. Okay, thank you. I think I'm running short of time. We have thank you.
Yeah, thanks, Joseph, for that wonderful talk.